Welcome back to Courtroom Chronicles, where real cases meet real consequences. Today, we're diving into State versus Sydnee Steele, a traffic case that spirals from a simple lane change into a full-blown courtroom showdown. What starts as a routine stop turns into a battle of perception. A veteran, officer's claim of reckless driving versus a young pregnant woman who insists she was just trying to get to her hair appointment before her baby shower. This case raises big questions. When does an officer's observation cross into assumption? And can a traffic stop truly hold up when it comes down to one person's word against another's? Stay tuned, because what happens inside this courtroom might just change how you look at everyday traffic stops and the thin line between safety enforcement and overreach.
Crimes,
Let's roll the footage.
issue citations, and make arrests based on your investigations.
Yes, I am.
Okay, then. So I want to bring your attention to March 20th of 2024. Were you working for the Clayton County Sheriff's Department at that time?
Yes.
And were you on duty that day?
Yes, I was.
Okay. Did you at any point in time have occasion to make contact or initiate a traffic stop with a white Chevrolet Trax that was driven by Miss Sydnee Steele?
Yes.
Okay. Can you tell me about what drove you to, or what caused you to initiate contact with Ms. Steele?
Yes. So during my role,
Lieutenant Carey, a post-certified officer with years in the Clayton County Sheriff's Office, begins laying down the groundwork. Notice how the prosecutor quickly establishes his credentials: experience, certification, authority. This isn't just legal formality, or it's strategy. By emphasizing the officer's credibility early, the state is building a foundation for the jury or judge to trust his later testimony. But watch closely. Credibility doesn't equal accuracy. Experienced officers can still misinterpret a situation, especially in fast-moving traffic. Do you think experience always guarantees precision, or can routine lead to overconfidence? Drop your thoughts below.
A little over 2 years.
Mm-hmm. And you have prior experience before that, correct?
Yes, I was with the Clayton County Police for 4 or 5 years.
Okay. And during that time, both with the Sheriff's Office and the Police Department, have you been post-certified?
Yes.
This is where the case starts heating up. The officer testifies that Miss Steele made multiple lane changes without signaling, following another car too closely. That sounds serious. Until you realize all of this is based solely on his visual judgment while driving himself. No radar, no dashcam. Just human observation through mirrors at highway speed. Here's the catch. Following too closely is subjective. What feels unsafe to one driver might look fine to another. And without a video recording, it becomes a pure credibility contest. So, if you were the judge, would you trust the officer's instincts, or would you need solid visual proof?
Yes.
Okay. Can you tell me about what drove you to, or what caused you to initiate contact with Ms. Steele?
Yes. So during my role during the day, I look for erratic lane changes, reckless drivers, speeders. So while traveling on Fair Boulevard, passing over 48, I was monitoring traffic in my rearview mirror. I observed a white SUV changing several lanes, not giving the public enough notice that she was changing lanes, nor was she using a nor was the vehicle using a turn signal. I observed the vehicle getting closer to me as she was changing lanes. She was also following another vehicle too close. Once she changed from lanes 2 back to lane 1 several times, she passed me. I'm sorry, from lane 3 to lane 2, she passed me in lane 3, and that's when I conducted a traffic stop on that vehicle and spoke with the driver. While speaking with the driver, she advised that she was in a hurry to get to Atlanta because she had a hair appointment.
Okay. You stated she didn't use any turn signals. Is that correct?
Correct.
Okay. And what was the basis of the following too close?
She was following another vehicle too close as she was changing lanes.
Based on your knowledge, your training, and your experience, as well as what you observed, was that a safe maneuver for her to make?
No, it was not.
Would a reasonably prudent driver um, was a reasonably prudent driver would a reasonably prudent driver have followed that closely?
No. And if that vehicle in front of her would have slammed on brakes, she would have been at fault, and that definitely probably would have caused an accident.
Okay. And with the improper lane change, was there anything improper? Tell me about what was improper about that lane change besides just the signal.
So when you change lanes, you have to give the public enough notice that you're about to change lanes, which she failed to do
Okay.
several times, not just one time.
Okay. So about how many lane changes did you observe?
I believe I observed three. So she went from the number 3 lane to the number 2 lane, then back to the number 3 lane.
Okay. To occur in Clayton County?
Yes, it did.
Okay. I have no further questions at this time.
All right, Ms. Steele, did you have any questions of Lieutenant Carey?
Yes.
Go ahead, ma'am.
So you said that you were observing me in your rearview mirror when I
Correct.
did all of these. Okay. So if you're observing me in our rearview mirror, how are you able to see how close?
Now this is where Miss Steele turns the tables. Her cross-examination cuts straight through the officer's confidence. She points out a key logical flaw. If he was watching her through his rearview mirror, how could he accurately measure the distance between her car and the one in front of her? It's a brilliant point, calm, logical, and delivered with the precision of someone who's thought about this a lot. Watch how the officer stumbles slightly here, admitting he can't determine how close her tires were, only her bumper. That's a subtle but powerful crack in the state's case. What do you think? Is this solid defense reasoning or just courtroom semantics?
I was with the Clayton County Police for about 4 or 5 years.
Okay. And during that time, both with the sheriff's office and the police department, have you been post certified?
Yes.
Okay. And being post certified, are you authorized to investigate crimes, issue citations, and make arrests based on your investigations?
Yes, I am.
Okay, then. So I want to bring your attention to March 20th of 2024. Were you working for the Clayton County Sheriff's Department at that time?
Yes.
And were you on duty that day?
Yes, I was.
Okay. Did you at any point in time have occasion to make contact or initiate a traffic stop with a white Chevrolet Trax that was driven by Miss Sydnee Steele?
Yes.
Okay. Can you tell me about what drove you to or what caused you to initiate contact with Miss Steele?
Yes. So during my role during the day, I look for erratic lane changes, reckless drivers, speeders. So while traveling northbound on Fair Boulevard, passing over 88, I was monitoring traffic in my rearview mirror. I observed a white SUV changing several lanes, not giving the public enough notice that
This is Miss Steele's side, and it changes everything. 6 months pregnant, running late for a hair appointment, and according to her, being tailed by the very officer who later accused her. Her testimony flips the narrative completely. She claims he was the one driving too close, forcing her to change lanes just to feel safe. She even points out her car's lane assist system, a built-in feature that physically resists lane changes without signaling. That's a modern tech defense you don't hear every day. At this point, the emotional stakes are high. She's calm, detailed, and confident. Everything a judge looks for in credible testimony. So, viewers, who's convincing you more at this stage? The trained officer or the pregnant driver just trying to make her appointment?
Rearview mirror, and I'm like, he is driving so close to me. Like, he was so close. I could not see his tires. This is why I asked these questions, because in driver's training, they teach you have to at least be able to see the car's tires behind you. So that's how I was able to determine that he was driving too close to me. It was not a car length behind me. So then I'm like, okay. So I put my signal on, get back in the left lane. He gets back in the left lane. So I'm like, what is happening right now? Like, I was so confused as to what's happening. I'm like, am I in his way? What's going on? So then I did get back into the right lane. And when I went to get into the right lane, that's when he turned his light on and pulled me over. And I was confused.
And there it is. Not guilty on all counts. The judge makes it clear. Both sides gave sworn testimony, but without hard evidence, the court simply can't prove guilt beyond a reasonable doubt. It's a reminder that in the justice system, reasonable doubt isn't just a phrase. It's the difference between conviction and freedom. This case isn't about traffic. It's about truth, perception, and the power of evidence. Without a dash cam or third-party witness, the officer's word wasn't enough. If you found this case as eye-opening as we did, don't forget to hit that like button, share your thoughts in the comments, and subscribe for more real courtroom breakdowns, legal insights, and verdict reactions every week. Until next time, stay curious, stay critical, and stay tuned.